now resume with the testimony of Dr. Oziel. Would you come back up here, sir, and take the witness stand? And would you state your name again for the record?
Dr. L. Jerome Oziel.
I will remind you that you're still under oath.
Yes, Your Honor.
All right, you may continue your cross-examination.
Thank you, Your Honor. Yesterday, sir, we were talking about a CV, a resume of yours that was dated 1988. And I believe you indicated, did you not, that you thought that was out of date?
Yes, it is.
And have you found a more recent one?
No, I was unable to find it.
Now, let's return, if we can, to the evening of October 31st, 1989, after Eric and Lyle had left, okay? You told us yesterday that you made a telephone call to a Dr. Lulo, correct?
That's correct.
Why did you call Dr. Lulo?
I called Dr. Lulo to ask another colleague what he thought was involved with respect to confidentiality in a disguised form, meaning I didn't reveal anything about the particular situation or the patients involved, but presented a theoretical situation and asked him what his perception was with respect to the limits of confidentiality and propriety.
So you had a question in your own mind concerning the limits of confidentiality or the scope of confidentiality?
No, I think I would state it differently. I would state that...
excuse me, but if you could answer the question. Did you have some doubt or uncertainty in your mind at that time about the limits of confidentiality?
I don't recall whether I had a doubt about the limits of confidentiality.
Did you have at that time an opinion in your own mind concerning the limits of confidentiality?
Yes, I did.
And did you call Dr. Lulo to see if he shared your opinion or disagreed with your opinion or had another point of view?
That would be correct.
And you said you gave him a theoretical situation to ask for his professional opinion.
That's correct.
And did this theoretical situation have to do with information that you had received from a patient first? Was that a component?
I don't know what you mean by that question.
Did you tell him, what if, or something like, what if a therapist receives information from a patient concerning the patient having committed a violent crime? Something like that.
I don't recall the exact conversation with Dr. Lulo, but it probably would have been something like that.
And did you also tell him, and after receiving this confession of a violent crime, the patient says things or does things that are perceived by the therapist as a threat against the therapist? Was that a component?
I think that that would have been a component.
And did you then say, does the therapist, or words to the effect, what should the therapist do? Should the therapist call the police? Does the therapist have the right to tell other people? Those questions.
I might have asked some questions in that line.
Well, is it accurate to say, Dr. Oziel, that the reason you were calling Dr. Lulo is because you were not certain of what to do at that point?
I would say that I was not completely certain what to do, having just been threatened. I'm assuming that I was, in fact, wanting to get a second opinion, if you will.
And would it be fair to say that having just been threatened as you perceived it, you were frightened?
Oh, it would be quite correct to say that I was frightened.
And you were therefore in an emotional state, not a totally calm, dispassionate state. Would that be fair to say?
Well, I would say I was calm, but I would say I definitely had the impression that my life was immediately going to be endangered.
Okay, my question was, though, however, the emotion of fear. Did you feel fear?
Yes, I definitely felt fear.
And you were concerned for your well-being?
I was concerned that I might be killed, yes.
You were concerned for your well-being.
That's what I stated,
correct?
right.
And did Dr. Lulo offer an opinion as to what you had a right to do or should do or could do, any of those things?
Yes, he did.
What did he tell you?
He told me that, in his view, that if I was threatened to be killed, or there was a clear impression on my part that that there was an imminent danger that I or other people might be in danger of being killed, that he perceived that I absolutely had an obligation to warn anybody in the sphere of danger that I perceived would be in the sphere of danger, that they were endangered, and to tell them whatever details of the situation I believed that I needed to tell them in order to allow them to appreciate the scope of the danger and to appreciate the fact that the level or intensity of danger that they were in. And that was consistent with what I had already concluded.
And that's what Dr. Lulo told you?
Words to that effect.
Okay. Did he tell you to call the police?
No, he did not tell me to call the police.
You're sure of that?
Best of my recollection, he didn't tell me to call the police.
Are you aware of the fact that Mr. Burt spoke to Dr. Lulo last night?
No, I'm not.
Did he tell you you couldn't call the police?
I don't recall him mentioning the police at all.
Did you mention the police? Did you say, am I now within my rights to breach confidentiality and call the police? Did you ask him that?
I don't recall having said anything about the police.
So you didn't, well, did it occur to you to call the police?
It occurred to me to call the police, and I decided that if I called the police, I might be killed.
Police were going to kill you?
No, Eric or Lyle was going to kill
Wait,
me.
let him respond. You
Eric-
asked the question, let him respond.
All right, so if you
Let him respond.
Sorry, Your Honor. Go ahead.
Have you finished your answer?
No.
Okay, you may do so.
Go ahead.
Counsel, I said he could do so, so we don't need you to echo what I just said.
All right, sorry.
You may answer the question.
No, the nature of what had occurred that evening was such that I was of the firm belief that Eric and Lyle were planning to murder me.
Move to strike
And-
the answer, Your Honor, as not responsive.
Objection overruled. Have you finished your answer?
No. And the perception that I had talking to the people that I talked to was that since there was no evidence of their having been involved in the murder, nor was there a suspicion that Eric or Lyle had anything to do with the murder based upon what Eric and Lyle had told me, that my relating that I had been threatened may not have been enough evidence for them ever to have been retained in custody. And if I told the police and they were released from custody, virtually everybody that I talked to said the
Your Honor,
best of their
I would
belief.
object to this as hearsay at this point, what everybody else told them.
All right, the objection is sustained as far as being hearsay. It's not being received for the truth of what was said, just to the state of mind, and received only to reflect the state of mind of the witness. You may continue.
That if I told the police that it would be a very high likelihood that specifically that Eric and Lyle would kill me. And that is why I didn't call the police, in addition to not wanting to call the police, because Eric and Lyle were my patients, and I didn't want to call the police and divulge the confession if there was any other way to try to limit the danger such that myself, my family, and any other party who could have been in danger would not be in danger. So I was trying to preserve my client's ability to not be turned into the police at the same time that I was trying to protect my life, the lives of my family, and the life of Judalon Smyth, who I thought collaterally might be involved. And that's why I didn't call the police.
Okay, now have you told us now everything about your reasons why you didn't call the police?
I think I've basically told you why I didn't call
Well, do
the
you
police.
want to think about it for a minute? Make sure you've told us everything.
I think I've told you substantially why I didn't call the police.
Okay, fine. Now let's go back through your reasons, all right? At the point when you called Dr. Lulo, you hadn't called anyone else yet. Is that true?
I don't recall the order in which I called people.
Well, why don't you tell us all the other people that you called that night from your office?
I think that, as I testified to previously, that I don't recall all the names of people I called. I actually called some policemen. I called
That night?
That night, yes.
Okay. What policeman did you call that night?
I didn't take the names of the policemen. I wasn't in a frame of mind such as to take notes about which policeman I called. I simply was calling different people to get impressions of things, specifically the amount of danger I might be in this situation.
Well, let me just stop you so we do this in an orderly fashion, Dr. Oziel. You just told us that you had ruled out absolutely calling the police. Now you tell us you called a policeman. Was this a personal friend?
No.
Was this at a police department? Did
No.
you call a police department?
May I explain?
Your Honor, might the witness be instructed to answer the questions?
Yes.
Then he'll be given an
At this
opportunity
point-
to explain.
Okay, counsel, don't speak to the witness. At this point, you can answer that yes or no, and if there's a need for an explanation, either a lawyer will ask the question or not, depending on what they choose to do. All right.
Now, did you, that night, as you've just told us, call a police department?
I did call a police department.
What police department did you call?
I don't recall.
You have no idea.
No, I don't have any idea.
You're in an office in Beverly Hills. Is
That's
that right?
correct.
Do you think you called the Beverly Hills Police Department?
I think I just testified. I don't know which police department I called.
Do you have the numbers of police departments in your office?
No, I do not.
How many policemen did you talk to?
I don't recall whether it was one or two.
Do you think you called more than one police department?
I don't recall if it was one or two.
Now, you were seeking some information from the police?
Yes.
So did you ask for any specialized department, or were you just going to talk to whoever was at the desk?
I think I just talked to, that night, whoever was at the desk.
And what did you tell this police person at the desk?
I didn't tell them anything. I just asked the question that, if in fact someone was involved in a crime and there was not any external evidence about the crime, in their experience, was it likely that the person would be convicted based upon my having stated that the crime took place?
And the desk person gave you an answer to that question with those facts?
That's correct.
Was it a male or a female?
I don't recall. I think it was a male.
And this person didn't ask you any follow-up questions?
We were just talking generally and hypothetically. The conversation may have only been 2 minutes long.
So you call a police department and someone answers and you say, I need to ask a question. Is that what you did?
Basically.
If someone has committed a crime and confessed a crime and there's no external evidence, how likely is their conviction? That's what you ask a desk officer at a police department. Is that right?
That would be correct.
And they didn't ask you what kind of crime. Is that right?
I don't recall. It was a 1 or 2 minute conversation.
And they didn't ask
4
who were
years
you?
ago. I don't know if they did or didn't, but I told them that I did not reveal who I was.
And they gave you some speculation on whether a person could be convicted or not based on the information you gave them.
They made a general comment.
So is it correct to say then, Dr. Oziel, your concern was not whether calling the police would have Eric and Lyle arrested, but whether you could guarantee they're being convicted? That was your concern, wasn't it?
Menendez.
Overruled.
No, that was not my only concern. That was a concern.
That was a concern.
Sure, it was a concern.
Now, who else did you call besides Dr. Lulo and this anonymous desk officer?
1 or 2 other attorneys who I don't recall, and I think I also talked to a police chief or assistant police chief in some small city, but not that night. It was probably several days later.
Several days later, you talked to a police chief in California?
No, I think I said, or some administrative person in the police department.
No, I think you just said police chief. Do you want to change that to administrative person in a police department?
Okay, counsel, now you're arguing with the witness, so rephrase your question.
Who did you speak to, a police chief or an administrative person in a police department?
I don't recall. I think it was one or the other.
And why did you call this small-town police department?
Just basically for the same reason, to find out what kind of situation it was that I was in.
Well, why would you call a small-town police department instead of the Beverly Hills Police Department or the Los Angeles Police Department or the County Sheriff's Department or the Attorney General? Why would you call a small town?
because I was trying to make a call in such a way that it would be as unlikely as possible that anyone could take even the theoretical situation that I was posing and link it with in any way to Eric or Lyle or my practice.
So I take it then it was a small town away from the spread of the publicity and coverage of the Menendez homicide. Is that right?
I don't really recall what it was or where it was. I didn't take notes of it, and it was 4 years ago.
How did you select which small town? Was it geographic, like far away in Northern California or Arizona or Maine or Spain or what?
I think it was just kind of random, just me thinking of just kind of checking these things out with multiple sources to get some check on my own judgment.
And how do you randomly select a small town police department to call? I mean, do you call information, say, give me the numbers of all the small town police departments?
No, I think basically I thought of a couple of small cities that were separate cities and just called one, and I don't recall which one it was.
You have no idea which small cities you thought of?
No, I don't.
Now, do you believe they were outside of Los Angeles? Wasn't a city inside Los Angeles?
I don't recall.
Well, you just said that you wanted to make sure that it wouldn't tip anybody off.
I mean,
I take it that means there was certainly publicity about the Menendez homicides in the Los Angeles area as of that time, was there not?
Yes, there was.
Okay. So if you're making an attempt to have it where no one would get tipped by the facts, I take it you would have taken it outside of Los Angeles County, no?
No, I don't think that it was outside Los Angeles County at all.
Was it outside of Los Angeles City?
I don't recall.
Well, if it were outside of Los Angeles City, that would have been a toll call, wouldn't it? And it would show up on your phone bill.
That's not necessarily true, but it might be true.
Okay, have you looked over your phone bill to see if you can find the number for the small town police department?
I certainly haven't.
And do you believe, Dr. Oziel, that by being this vague about what you called, it would be impossible for us to look at those phone records to either verify or dispute what you're saying? Does that occur to you?
Overruled.
Is that your reason for being so vague?
I think my reason is that I don't recall.
And you
who I
took
called.
no notes of this contact with this small town police department, is that right?
I'm sorry? Could you repeat?
No notes, I think
No.
you just said.
No, I didn't.
And did you tell this small town police department that you had in your possession a confession to murder, to double murder? Did you tell them that?
No, I did not.
Did you tell the desk officer at the unknown police department that you had in your possession a confession to double murder?
No, I did not.
No, you didn't. What you did was you told them you had been threatened. Isn't that true?
I don't recall specifically what I told them, but I know that I didn't tell them anything about a double murder.
Well, did you tell them you had a confession to murder?
I don't even recall that I told them that.
So did you tell them you knew that there's someone who committed a crime and that person threatened you, and what was the likelihood, based on that, of the person being convicted? Is that basically what you were saying?
Something like that.
So you never told them that you had a confession, is that right?
I don't recall that I ever told those people that I had a confession, no.
Did you tell any of the people that you called over the next measurable period of time for input that you had a confession?
Yes.
Who'd you tell that to?
I believe I told that to Brad Brunon.
Brad Brunon is your lawyer, is that right?
That's correct.
And when did you first connect with Brad Brunon?
I don't
You already
recall.
told us you didn't reach him on the 31st, so when did you?
Well, I don't know that I stated I didn't reach him. I don't recall having reached him on the 31st. I might have, just don't know.
All right, when do you recall telling him?
I don't recall. I just recall that I made some phone calls that night, and I made some other phone calls over the next couple of days, and I really don't recall which person I talked to that night except Dr. Lulo, although I do know that I made more calls that night because I spent something like, as I recall, maybe 15 minutes to a half an hour, something like that, in the session. And the conversation with Dr. Lulo, as I recall, was pretty brief.
When did you tell Brad Brunon that you had a confession?
I don't recall whether it was that night or within the next several days.
Well, was it either that night or over the next several days?
I believe so.
And did Brad Brunon tell you that if you had a confession to murder, that that was not evidence that you could go to the police with? Did he give you that advice too?
Your Honor, may I ask if that's attorney-client privilege or not?
I think the...
Counsel, if you want to argue the matter, we can do it at the sidebar. All right.
Now, that night you said, I believe as part of a previous answer, that you think you made about 15 minutes worth of phone calls. Is that right?
I think I said that I was in the office somewhere around 15 minutes to half hour. I don't recall exactly how long.
Were you making phone calls during that time?
Yes, throughout most of the time.
All right. Now, you've told us that you don't remember who you called with the exception of Dr. Lulo and a police desk person. Is that right?
No, actually, I think that for sure I know that I called my wife.
Well, we're getting there. You remember calling your wife?
Yes, I do.
Okay. And did you tell your wife that you had been threatened and that she should take the kids and get out of the house?
Words to that effect.
Okay. And to the best of your understanding, was your wife complying with that?
Yes, she did comply with that.
And did you go over to your house after you left your office to get anything?
No, I did not.
And where did you go to stay that night?
I went to the home of Judalon Smyth.
Now, you have told us very explicit language, Dr. Oziel, that you were in fear of imminent murder at the hands of Eric and Lyle Menendez that night. Is that right?
Objection argumentative.
Is that how you felt?
Objection is overruled as far as the words that you used, Ms. Abramson, but perhaps you can rephrase it in a less argumentative tone.
Is that how you felt? Imminent danger of murder at the hands of Eric and Lyle Menendez?
Yes, I did.
Okay. And therefore, you wanted to put yourself out of danger. Is that right?
That would be correct.
And I think you've also said you thought your wife and children would be in danger.
That's correct.
And you love your wife and children, do you not, Dr. Oziel?
Yes, I do.
So you had your wife take the kids and go to a hotel. Is that what you did?
No, that's not correct.
Well, she went to a neighbor's that first night?
That's correct.
And you didn't seek to be with your wife and children to look over them at this time of great danger?
Actually, I thought that if I was with my wife and children, that would increase their danger immeasurably, because my fear was that that Eric and Lyle might that evening have come looking for me. They knew where I lived, and I was afraid that if, in fact, in some way they could have followed me to where I was, they would have found me with my wife and children. The reason I stayed away from my wife and children was specifically to be protective of them.
So instead you went to Ms. Smith's and put her, based on what you're telling us, in danger. Isn't that what you did?
Actually, I didn't think at the time that Eric and Lyle would have been going to Ms. Smith's. Eric knew where I lived, and my concern, my most immediate concern, was that the highest probability was that they would go to my house, and for that reason I didn't go to my house.
I thought I just heard you say you thought they might follow you. They could have been out there lurking. Didn't you consider that?
Yes, they could have been.
And so if they were out there lurking, you were about to lead them to your girlfriend. Is that right?
Well, if in fact they were out there lurking, that would be correct.
And up until that point, on October 31st, had you ever mentioned your girlfriend to Eric and Lyle Menendez?
No, I hadn't.
Did you have any reason to believe that they even knew that you had a girlfriend?
By the way, the word girlfriend is your characterization, but no, I didn't have any reason to believe.
Would you be more comfortable with the word lover?
You're going to characterize the relationship any way you like, so I don't care which word you use.
Well, you
I just
did tell us it was a relationship with, you had a sexual relationship with this woman.
Yeah, I said there was a sexual component to it, right.
Okay. And it wasn't a business relationship, the sexual component. I mean, this wasn't prostitution.
No, there was a business relationship, but the sexual component ended after the business relationship.
But the sexual part was based on feelings, not on money. Is that right?
That would be correct. No.
So you decide, strike that At this time, October '89, did you have credit cards?
I believe so.
Did you have money?
I don't know how much money I had with me.
Okay, but you had credit cards with you.
Yes, I did.
And you made a lot of money, did you not, in your practice? You were well off?
I don't know what well off is, but yes, I make a decent income.
So you could have afforded to go to a hotel, could you not?
Yes, I could have.
Instead, you went to Miss Smith's house, and when you got there, or shortly thereafter, you told her details of the confession of Eric Menendez, did you not?
Yes, I did. Some of them.
And you told her that, understanding that Eric Menendez never thought for 1 second that you were going to go and tell your girlfriend what he told you. Isn't that true?
Well, I don't think I was understanding or thinking about that as a concept at all.
And you told her that under this notion, I take it, that you having been threatened, she was somehow in danger. Is that right?
I definitely thought that she was in danger.
Okay. Now let's talk about that. Before you drove to her unknown, as far as Eric and Lyle were concerned, location, how was she in danger?
I'm sorry, I didn't understand what you said.
Okay, I think you've testified that to the best of your knowledge, neither Eric nor Lyle knew of her existence, correct?
Correct.
Knew where she lived, correct?
Correct.
Knew that you'd be choosing this night to go stay at her house, correct?
That's correct.
You didn't tell them, oh, you frightened me, so I'm going to go stay with Miss Judalon Smyth.
No, I didn't.
Okay. So they knew nothing, as far as you knew, about this woman that you were having this relationship with. Is that right?
That's correct.
But you felt that she was one of the people that you had to warn of this threat. Is that right?
That's correct.
Now, let me see if I understand this. The only other person you warned of this threat was your wife, right?
That's correct. And
your wife is also a psychotherapist, right?
yes, she is.
And your wife already knew that you knew the Menendez family and that they were, the boys were patients. Is that right?
That's correct.
And you felt, did you not, that your wife as a therapist who knew about your practice was someone you could tell things to and it would stay confidential, right?
That's correct.
Judalon Smyth was not a therapist, was she?
No, but I did have a confidentiality agreement with her.
Well, we'll get to that. She was not a therapist, was she?
No, she was not.
And she did not work for you at that time. You had no employment contract with her. You paid her no salary. She had done no work for your therapy practice whatsoever. Is that correct?
That's correct.
Now, you just said you had a confidentiality agreement with her. Did you believe, Dr. Oziel, that you could get, for example, your plumber to sign a confidentiality agreement, and if he was working on the pipes, he had a right to hear what was going on in your therapy sessions?
No, I didn't.
Did you think you could get your barber to sign a confidentiality agreement, so if you chose to talk to him about what your patients told you, somehow it would still be confidential?
No, just people who had some potential access to my records and who I believed might have access to confidentiality records. Those people, I have signed confidentiality agreements, even if subsequently they never have access to my records, just as a precaution for the benefit of my patients.
And do you think that if you get somebody to sign a form that says they will, what, keep things confidential, that you can then tell them the contents of therapy sessions? Is that your understanding?
No, the primary reason I told Judalon Smyth is because I feared her life was in danger.
That's not the question. Let's just deal with them one at a time, okay?
Okay.
Is it your belief that if you get someone to sign a confidentiality agreement, you can then go around and tell them what your patients are telling you? Is that what you believed?
No, there were limited instances in which, on an as-needed basis, people who have signed confidentiality agreements, who have some relationship to your practice, definitely have access to materials that are confidential. As a matter of fact, that happens on a regular basis in all psychotherapy practices.
Is that no?
If you repeat the question, I'll see if I can answer it now.
Reporter, read the question back.
Thank you, John.
Is it your belief that if you get someone to sign a confidentiality agreement, you can then go around and tell them what your patients are telling you? Is that what you believe?
I don't think I could answer that question yes or no. I think I'd have to explain.
Well, let me see if I understand what you've said before. You said you had certain people sign confidentiality agreements because they had access to your files. Is that right?
Or might have.
Or might have access to your files, right?
Or confidential information.
Well, let's just take it one step at a time. You mean confidential information from your mouth?
Well, no, not necessarily from my mouth. People who would be in a position to even be cleaning the office in which I keep confidential, any confidential information, or perhaps someone who is a bookkeeper who ordinarily just does bookkeeping entries, but who might, by chance, see something confidential. Anybody who could have access to confidential information, I try to have them sign confidentiality agreements, or that's at least a policy that I've had in my office. I don't personally get all the people to sign them.
Does your cleaning crew have a confidentiality agreement?
Yes, not the cleaning crew, but specifically the person who's responsible for cleaning the office does have a signed confidentiality agreement.
And does that make you think that if you were in the office late at night and the cleaning person came in, you could sit down with her over a cup of coffee and tell her what your clients told you that day, and that would still be confidential? Do you think you could do that?
Absolutely not.
All right. Now, what you're talking about is people who may be around the paperwork of your practice, like your appointment book, who might see a patient name inadvertently. You tell them they're not allowed to go out there and say, oh, Dr. Oziel has, Elvis Presley for a patient. That's what you mean, in part. Is that correct?
That's correct.
Now, the actual files, you told us earlier, yesterday, that you do these notes periodically, correct?
That's correct.
And they go in files by patient name, correct?
That's correct.
And you keep those files by patient name at that time where?
In my bedroom, in a filing cabinet.
In your house, is
Yes.
that right?
In a closet.
Is that correct?
In a closet in my bedroom, right?
Closet in your bedroom. At that time, did Judalon Smyth have access to your closet in your bedroom in your house?
No, not to my knowledge.
And that's where the notes that might reveal what your patients are saying to you in confidential communications, that's where they were kept at that time, in your house, correct?
Not all of my records. There were other records that were other places.
I'm talking about the files that have patient statements in them.
The patient files were kept in the filing cabinet, but notes from my day's practice that I complete at the end of the day would often be in my attaché case, as would be a phone book with patient phone numbers. And so there, is always a remote possibility that someone could open up my attaché case or somehow or other get access to data in places other than the filing cabinet in my bedroom closet.
Okay, so the patient files with the notes were kept in this filing cabinet in your bedroom closet. Is that what you're telling us? That's where the filing cabinet was?
That's where that filing cabinet
All
was.
right, but you might have a few notes from a particular day still in your attaché case. Is that right?
That's correct.
And do you leave that in your office, unlocked?
The attaché case?
Yes.
No, I bring it with me.
Okay, so it's with you.
Yes, it is.
All right. And did you have any reason to believe Judalon Smyth or the cleaning man was going to go rummaging through your attaché case?
She certainly could have.
Well, was she around your attaché case?
At times.
Did you have any notes from the session of October 31st in your attaché case on October 31st?
No, I didn't.
Now, you had Judalon Smyth sign a confidentiality agreement when?
We had a confidentiality agreement, I believe, sometime in June, and I don't recall the date.
Well, in fact, there is a document that you claim is a confidentiality agreement with her that's dated June 1st, 1989. Is that right?
I don't know. You have the document.
And you're aware of the fact that Ms. Smith claims that that was a forgery.
Objection. Calls for Thursday, Your Honor. Move to strike.
Objection sustained to the question. the jury's admonished to disregard it.
Now, I take it, Dr. Oziel, since you keep your patient files in your home, that all people who live in your home, therefore, potentially have access to the confidential communications of your patients. Is that right?
Well, remotely, but yes.
And that would include people who live in your home, such as Cynthia McPhee. Is that right?
I don't know if that would apply to that person.
Well, she lived in your home for what, 5 years, 6 years?
Something like that.
And you kept files in your home during that time?
Yes.
And would that also apply to people who would work in your home, like Alexandra Corey?
Not necessarily.
Was she in your home?
She was in my home, but not somebody who would have necessarily had any access to confidential information.
But Ms. Smith didn't work in your home in October of 1989, did she?
No, she didn't.
So wouldn't it be fair to say that at least with respect to those files in the cabinet, in the closet, she didn't have access to those things at that time? Is that right?
That's correct.
Now, I would like you to explain all of the reasons why you told Judalon Smyth what had occurred at your office on the night of October 31st. All of your reasons. You can get them all out now at once.
Okay. I need to ask for some assistance from the court. A significant part of the reasons that I told Judalon Smyth and believe...
Oh, just wait.
We need to approach.
Okay.
This is going to say you can all approach.
I'm not sure about that.
And there are some matters that the lawyers and I have to spend a little more time discussing, so we'll take our morning recess, and it'll take us a little while to finish off and then take a break, let the lawyers all take a break. So if you would all return to your respective jury rooms at 10 minutes to the hour, that's enough time so that we can discuss our matters and then also give everyone a break. So 10 minutes to 11. And don't discuss this case with anyone or form any final opinions about it, and we'll see you back here then. All right, as soon as all the jurors have left, have they?
Summary meeting, sir.
Okay. All right, we'll conduct a brief hearing with the witness, and then we'll have another hearing in a closed session with just the defense and the witness present. Relating back now to the issue of privilege, attorney-client privilege, and your conversation with Mr. Brunon, you had a question in that regard. All right, if you want to come out, you can come out.
Okay.
Yeah, go ahead. Yeah. And your question had to do with privilege. Did you want to discuss that with Mr. Brunon, or how did you want to deal with that?
If there is no way to have advice about whether or not that is attorney-client privilege from the court or from anyone else, then I would want to discuss that with Mr. Brunon. Yes.
Well, you have a right to discuss it with your attorney. The question is whether or not the answers you've already given constitute a waiver of privilege as far as that conversation is concerned, and that there were questions asked of you as far as whether you told anybody that you had obtained a confession from the two defendants, and you had indicated in response to one of those questions that Mr. Brunon was an individual that you had relayed that information to. So there's an issue of whether you've waived that privilege by that answer already. But I'll certainly give you a chance to discuss it with Mr. Brunon if you want, or to make a phone call or whatever you want to do and discuss it with him.
I appreciate that, Your Honor. My only concern was whether I would waive some general attorney-client privilege by answering the questions about that specific conversation.
No, it relates only to that conversation at this point.
Then I would feel comfortable discussing that.
Okay. All right, then the other issue deals with a matter that was going to be a response to the last question that was asked. It was a rather broad question, and you had an answer that you had some concerns about as far as whether it might disclose certain things that have been subject of rulings of the court. Is that right?
That's correct.
Okay, so what we'll do is have a closed session at this point and have the witness relate to the court his answer, and then if it does touch on privileged issues, we'll deal with it at that point. So we'll exclude the public and the prosecution at this point until the matter has been resolved. The cross-examination, Dr. Oziel, if you'd get back on the witness stand, the record will reflect that both juries are in the courtroom as well as all participants. All right, you may continue your cross-examination.
Okay, Dr. Oziel, you told us that after Eric and Lyle left your office on October 31st, you felt that you were in danger and your wife and children were in danger and Miss Smith was in danger. Is that correct?
That is correct.
And therefore you told Miss Smith the details or some of the details as, in a sense as a warning to her, to alert her to danger. Is that correct?
That's correct.
Now, the following question is directed at why Miss Smith was a person who you considered to be within, shall we say, a circle of danger, okay? Do you understand the question?
I believe I do.
All right. Then could you, first of all, was there only one reason why you thought Miss Smith was a person within that circle, or was there more than one reason?
There was more than one reason.
Okay. Could you give us the first reason?
One reason had to do with the fact of me simply being with Miss Smith at all, having her in my presence, and having been in a relationship, and also from her standpoint, having expressed an intention to continue in a relationship with me. So having a close relationship from a personal standpoint, so that's one reason.
Okay, let me ask you some questions about that first reason. Now, you've made it very clear to all of us that you were feared you were in imminent danger of being murdered that night. So could you not have avoided this particular aspect of her danger by simply having nothing to do with her? Couldn't you have just decided, rather than reveal what your patients had been telling you, to have nothing to do with her at that point?
I don't believe that I can answer that question until you ask me the other reasons that I also thought that Ms. Smith was in the zone of danger, because you're isolating one, the first one only, and the answer... Okay.
You cannot answer that.
Sorry.
Clear question.
Yes, I
Well,
can
let me
answer
ask you
it.
this question. Did you think you could extricate yourself from a relationship with Miss Smith as of October 31st, 1989?
No. Not very probably, very easily.
And did that have something to do with her, what kind of person she was, or what was going on in the relationship?
Yes, I would say that that's part of it.
Okay. And would you tell us what that was? That could you just not get away from this woman?
Objection, irrelevant.
Overall.
She was, I thought, at the time, evidenced by things she said and by things that she had written, extremely involved with me to the point where I had tried to break off that relationship multiple times, and Ms. Smith had continued to assert herself in terms of trying to stay in the relationship, and I did not believe that it was going to be very easy to not have her just not have her be around or have an association with me.
You mean you couldn't avoid being around her physically? Is that what you're saying? She followed you. She showed up in your house. She dogged your steps. She stalked you. Is that what you mean? You couldn't physically separate from this person?
Sustained.
Are you saying you couldn't physically avoid this person?
I'm saying that I think it might have been difficult for a number of reasons.
Even for a licensed psychologist?
I don't understand what that means.
Well, you have certain people management skills, don't you?
Yes, I think I do.
But you felt that this woman and her insistence on staying in this relationship was beyond your skills to deal with. Is that right?
She wasn't easily responding to me saying that I wanted to not have further dealings with her. That's correct.
But you didn't want to have further dealings with her. Is that what you're saying?
That's correct.
Overruled, the answer will stand.
Did you think she was a stable person?
At that time?
Yeah.
Not very.
So you went to the home of this not very stable person, and you told her that the Menendez brothers had killed their parents and had threatened to kill you, and you were in danger, and she was too. Is that right?
I don't think I said those words that way, but I did reveal some of that content. That's correct. I disclosed that as a warning
To an unstable person.
to someone who at that time was not very stable.
Was it your intention, Dr. Oziel, to have someone go to the police and blow the whistle on the Menendez brothers at that point?
I think you know very well that it was not my intention at all to have that occur.
Well, whatever I know is not really the issue here. That was not your intention, though. Is that true?
I made every effort to avoid that.
In fact, it was Miss Smith on March 5th, 1990, who went to the police and told them that the Menendez brothers had confessed to you. Isn't that true?
That's
Call
correct.
for hearsay, Your Honor.
Objection sustained, the answer is stricken.
To the best of your knowledge, you saw a search warrant, did you not, for your home? I think the search warrants come out.
I saw a search warrant.
And you were told by the prosecution, and you were told in the course of that search warrant, that she was the source of the information.
Your Honor, calls for hearsay also assumes facts not in evidence as to the affidavit.
Objection sustained.
You had telephone conversations with Miss Smith even after the search warrant was served. Isn't that true?
I don't recall that. I mean, it might be true. I don't recall it.
You went to her house and visited her on March 19th, 1990. And you later learned, did you not, that that entire visit was tape recorded by the police?
Yes, I received some tapes from the police, but I don't recall the sequencing.
Do you recall that you learned that you, at one point when you were at her house in March, that the police officers were hiding in the closet while your conversations with Miss Smith were being tape recorded?
At one point, I learned that.
And wasn't at least part of the subject matter of that conversation your unhappiness with Miss Smith for having gone to the police? Didn't you say that to her?
Absolutely.
Now, apart from the fact that you could not extricate yourself from this relationship, oh, let me strike that. As of October 31st, 1989, you had known this woman for how long?
Not very long, several months.
Not very, what is several months?
Sometime June through October, I guess.
When in June did you meet her?
I don't recall the exact date.
Did your acquaintanceship with her begin with a telephone call from her?
Yes, it did.
And at that time, was it your understanding she was calling you from outside of the Los Angeles city area?
I don't know where she was calling me from.
And was it some weeks after that telephone call that you first actually met her?
I believe so.
And did you first meet her at her home?
I believe so.
You went to her home?
That's correct.
So you had known her 4 or 5 months at the point of October 31st, 1989?
4 months, 4 to 5 months. I think that would be roughly accurate.
And for how long had you been trying to extricate yourself from the relationship as of October 31st?
Probably for about maybe 1 to 2 months. Pretty
So-
soon after the relationship began.
And how long after you met her at her apartment did you start having sex with her?
I don't recall that.
Was it immediately, or was it a matter of weeks, days, months?
It certainly was not a matter of days. It may have been a month. I just don't recall.
So would it be fair to say that you start having a sexual relationship with her, and after about a month of that, you want to get away from her?
Something like that.
Did you give her therapy during the time that you knew her?
Absolutely not.
Did you ever give her drugs?
Absolutely not.
She sued you claiming that, didn't she?
She claimed it.
You settled the lawsuit, didn't you?
I didn't settle it, no.
Your insurer did.
The insurance company settled it, but I have a pending claim against Ms. Smith.
They settled it for between $400,000 and $500,000, did they not?
Actually, and I need advice from the court with this, settlement was a confidential matter, and if there's any information that was disclosed by Ms. Smith, there was a breach of contract. So I'm feeling that I'm put in a difficult position here because I'm not supposed to discuss anything about the settlement.
All right, the court will sustain the witness's objection to the question. Ask another question.
Maybe we just strike it from the record.
The
Well,
answer,
he did
the
not-
question is stricken as, at this point. Objection sustained.
Well, I'd like to be heard on that, Your Honor.
All right, you can be heard at another
All right,
time.
thank you. Now let's move on to the other reasons why you told this unstable woman you were trying to get away from your patient's secrets. What were the other reasons? Yeah, well, let's just do one at a time. What was the next reason?
I wouldn't characterize what I did as telling them my patient's secrets. I would
Your Honor,
characterize
can
it
we
as a
strike
warning.
that as not responsive?
No, objection is sustained. The answer was responsive in that it's responsive to the question. So objection is, your objection is overruled. Ask another question.
When
Rephrase
Eric
your
talked
question.
to you on October 31st, he was telling you a secret, wasn't he?
Yes, he was telling me a secret.
And what patients say to their doctors are called, are they not, confidential communications at the time they are spoken. Is that correct?
Unless there's an exception.
At the time they are spoken, they are called confidential communications. Is that right?
Ask and answer, Your Honor.
Overruled.
I believe they're confidential unless there's some exception to privilege.
And you tell your patients, you've already told us about confidentiality law. Is that right?
Yes.
Now let me ask you, Dr. Oziel, in 1989, before this case, what did you tell your patients about the privacy of what they're telling you about their lives in your office?
Objection irrelevant.
You're asking in general or as to the defendant?
Well, he's already said that he tells
Well,
them all.
counsel, I'll just answer my question.
Generally.
Be responsive to my question.
All right, I will. Generally.
All right. Objection overruled.
In general, I tell patients about confidentiality in psychotherapy sessions.
Well, tell us what you tell them. Pretend we're all your patients.
Ordinarily, what I do is I disclose fundamentally the evidence code with respect to the exception to confidentiality, that therapy is confidential unless certain conditions take place, and then go through some of the conditions that are likely to be exceptions.
Pretend we're your patients. Tell us what you'd say to a patient.
Just what I said, and then I add the exceptions, which have to do with danger to oneself,
Excuse me?
danger to oneself, danger to someone else, inability to care for oneself, elderly abuse, child abuse, areas like that. And I tell people that those are basically the conditions under which there is not confidentiality.
Well, I don't understand. I'm a dumb patient. I've never talked to a therapist before. And if you're telling me, you say to them, there's confidentiality except danger to oneself, danger to another, abuse of the elderly. I don't understand what you're saying. What do you tell them about what you're going to do with the information they give you?
I don't tell them anything beyond that it would be confidential except under those circumstances.
Well, what do you mean by that? How do you explain when they say, I don't understand, Dr. Oziel? What are you talking about?
They don't say that.
Well, let's say they just did. What do you mean?
That's theoretical and speculative.
So when you say to them, that's all you say to them. So you don't say to them, for example, if you are my patient and you tell me that you are sexually molesting your child, I have to call the police. Do you tell them that?
Sometimes, but not always. I mention the exceptions, and I can't say that every single time I go into that elaborate detail.
But in fact, in the state of California in 1989, there was a statutory reporting law, was there not? So that if someone did tell you they were molesting a child, you had to report it to the police. Isn't that true?
That's absolutely correct.
All right. Now that's a mandatory reporting requirement for child abuse, correct?
It certainly is.
Okay. And let's assume hypothetically you have a patient who's a child. Do you tell the child patient, now if you tell me that you are being abused in any way, physically or sexually or any other way, I have to report that to the police and turn in your abuser. Did you tell that to the kids?
I-
That's vague as to, is she talking about kids or who's talking about?
Patients?
Objection sustained.
Oh, do you tell patients who are minors that if they reveal to you information that they are abused, you have to report that? Do you tell that to them?
That depends very much on the age of the child.
I said minors, under 18.
Usually I do.
Now, when it comes to this danger to oneself, how do you explain that? What does that mean?
Well, if someone were to ask, I would talk about, for example, being suicidal or harming oneself.
And you tell them if you're suicidal and you harm yourself, I must report it or I might have to protect you.
I might have to protect you.
Because that's not a mandatory reporting law, is it?
No, it isn't.
And now tell me how you explained in 1989, if you did explain it, danger to another.
Danger to another really just reflects any belief that you are about to harm someone else.
And so you tell that to all of your patients.
I tell virtually all patients, to the best of my recollection, at the beginning of therapy.
And you tell them all that. If I determine that you're a danger to another person, then there's no confidentiality. You tell them that.
Yeah, I go through the list of those things.
And do you tell all your patients, if you threaten me, I'm going to tell my wife and girlfriend?
The answer would be that doesn't exist anywhere in any code, and I've never even seen anything written on patients threatening their therapist, so that would be very difficult to tell a patient.
Okay, in fact, Dr. Oziel, in 1989, there had never been a case that you knew of, there was nothing in the code, there was nothing in your training that told you that if a patient threatened a therapist, that was a breach of confidentiality. Isn't that true?
No, I wouldn't say that is true. I would say...
I thought that's what you just said. Isn't that what you just said?
No, I don't believe I did. I think what I said is that there's nothing specific in the literature that I could find on an instance of a patient threatening a therapist to specifically describe for a therapist the parameters of what the therapist should do under those circumstances. But since the therapist is a person, and if in fact the patient is in danger of harming any other person, the therapist being another person, the best that I could do at that time was to apply those evidence code exceptions to my case. And the best of my recollection, it took the Superior Court, Appellate Court, and Supreme Court to litigate that matter, that there was absolutely no written material on what a therapist does when his life is threatened. I couldn't find any, and no therapist that I've talked to since has ever found any.
Right. Exactly. So that as of...
Not editorialized, just ask a question, please.
So as of October 31st, 1989, you did not know exactly what your rights were or duties were because there was nothing before like this in your experience. Isn't that true?
Nothing before like it at all in my experience.
So I take it then that when you told Eric and Lyle about the limits of confidentiality on October 31st, you couldn't have told them, and if you threaten me, I have a right to do thus and such, because you didn't know that then. Isn't that true?
No, it's not true. I was applying the evidence code exceptions at the time, and evidence code 1024 says that under conditions where the patient is a threat to another, that there is no confidentiality. And on that basis, I told them that if in fact they were threatening and threatening to harm me or anyone else, that there would be no confidentiality. And that is in fact what I told them.
You told them that on October 31st.
Absolutely.
You said, if you threaten me, there's no confidentiality.
Absolutely. I said if you threaten anyone, if you are threatening to anyone, threatening to harm anyone, there is no confidentiality. Absolutely, I told them that.
You told them both that.
Yes, I did.
And did you then tell them both, now I feel threatened, so there's no confidentiality?
I told Lyle very expressly that he was menacing to me. In
And
fact,
did
I
you tell
told him several times that he was menacing and threatening to me.
You didn't tell that to Eric?
No, I didn't perceive that Eric in that session was being threatening or menacing to me.
You just thought he was going to murder you that night? Is that right?
I thought that...
Yes? Is that yes?
I'm trying to answer the question, and I can't answer it yes or no.
Okay.
Would you like me to explain it?
No. Did you tell Lyle, after you told him you thought he was being menacing, that therefore the Evidence Code Section 1024 of the California Evidence Code now clicks in Lyle, and therefore nothing you've told me is confidential? Did you tell him that?
No, I didn't feel there was any reason or obligation to tell him that.
Oh, well, did you tell him, well, remember what I just told you about confidentiality, Lyle? I'm finding you very menacing, therefore there is none.
Slow down, please.
Sorry. Yes, did you say words to Lyle to the effect, remember, Lyle, I just told you if you threaten anybody, there's no confidentiality. Now you've threatened me, now there's no confidentiality. Did you tell him that?
No, and I didn't believe there was any reason to tell him that.
Let's go back, then, to Miss Smith. You called her from the office also after you called your wife?
I may have. I don't recall. Probably.
Did you call her before you called your wife?
I don't know what order it was. I think I called my wife first.
Okay, and did you tell your wife when you called her that you would be staying at Miss Smith's house that night?
I think I told her that I probably would be staying at Miss Smith's house that night, something like that.
And then you may have called Miss Smith?
I believe so.
And then you went to Miss Smith's house?
That's correct.
And how many days did you stay there?
Several days.
You slept there several days?
That's correct.
Were you hiding out there?
Pretty much.
On November 1st, the next day, did you see 11 patients?
I don't recall how many patients, but I did see patients the next day.
In your office?
That's correct.
And Eric and Lyle certainly knew where your office was, didn't they?
Yes, they did.
Now, the second reason, apart from your inability to extricate yourself from this woman that you told Miss Smith, was what?
The second reason is that I was concerned that Lyle and Eric might go to my house, since they knew where I lived, and that they might discover some materials in my house that would potentially link Ms. Smith as a very likely person who could have information about whatever they disclosed. And since I had reason to believe that whoever was in possession of such information, or could have been, would be in danger, I thought that was another basis for telling her.
Did you think they were going to go to your house that night and start looking through your house and come upon this information?
I thought that was a possibility.
Okay. And you were afraid that if they found something in your house, they would have figured out that this person knew about their confessions to you. Is that what you thought?
I think that's probably overstating it. I think that they could have easily pieced together, based upon the kinds of information that were in my house, that there was a relationship such that that she could be one of only two people that that could be in the danger zone at that particular time.
Okay, so tell me, what was this information at your house?
The information had to do with two categories. One would be a large number of business projects, all of which had to do with tape recording and tape duplication, and also a confidentiality agreement, which would have indicated that there was some access to confidential information. And secondly, there were...
That's two. Is this three?
I don't know which number we're on, Ms. Abramson.
Okay, well, we have a large number of business projects. That's paperwork, I take it?
Yes, a lot of
Okay.
paperwork.
A lot of paperwork. And then there's a confidentiality agreement signed by Ms. Smith?
That's correct.
Okay. And then what else would link her to you in a way that would tell them that she knew?
There were a number of letters that she had written, which were very explicit letters that expressed a lot of intense feelings that I think would have linked together the business and tape recording function with the fact that she had had an intense, close personal relationship with me. When putting those two things together, and the fact that it was pretty easily discoverable that I had been very regularly, for a while anyway, in her company, she had been in mine, and that they could have determined by following me in the days subsequent to that night that there was a relationship with her. I just felt that if I didn't warn her, I would be very derelict, because she absolutely could have been in imminent danger.
So there were love letters in your house from Judalon.
That's your characterization, I guess, if you want to call them that.
Well, if they weren't love letters, they were some kind of explicit, what, sex letters? I mean, personal letters.
No.
Isn't that what you mean?
Didn't say they were sex letters. I said they were they expressed intense emotions towards me.
Okay. So there were these letters from her expressing intense emotion towards you that might have let these boys, if they had gone to your house and started reading your mail, figure out that you might have had a girlfriend named Judalon. Is that it? As far as the letters are concerned.
Who was involved in the tape duplication business and who had signed a confidentiality agreement with respect to my patients?
Let's just start with the letters. They would have figured out from the letters that this lady is a romantic love girlfriend person. Is that right?
Yeah, a person who was extremely attached to me in a romantic or affectionate way, whatever.
You had an entire bag or bags of love letters in your house from a variety of women at that time. Isn't that true?
No, it isn't true. Oh.
Didn't
it
you,
isn't
in
true.
fact, show love letters from other women to Judalon?
I don't recall that, and if so, I don't believe that they were in my house.
And didn't you show similar love letters from other women to Alexandra Corey
Don't
when
recall
she
that.
was your girlfriend?
Yeah, don't recall that.
How about Cynthia McPhee? Didn't you show her letters from other women that you kept for years in your house?
Your Honor, may we approach, please?
Yes.
Now, these explicit letters from Miss Smith that were in your house on October 31st, did they have her home address on them?
Yes, a lot of them did.
Do you still have those letters?
No, I believe that counsel has them.
Your counsel?
Yes.
And which lawyer has them?
Perhaps we want to talk about something in the sidebar again.
So, well, I'm not going to pursue it beyond finding out where they are, Your Honor.
Objection overruled.
Who has them?
I believe it would be a Mr. Salzman.
What's his first name?
Stanley.
Now, I take it there was nothing in those letters, however, that mentioned your telling Miss Smith the contents of any therapy you had conducted with any patients.
No, there was not.
And I take it there was nothing in those letters that said, I look forward to your revealing to me your client's confidential communications.
No, there was not.
So there was no reference, I take it there was no reference to your patients in those letters. Is that true?
No, there was not.
Now, the confidentiality agreement you said was in your house, and if Eric and Lyle came upon that on the night of October 31st, they might think that, what, that you had already told her something?
I didn't know exactly what Lyle or Eric might think. I just saw Lyle and Eric as being very bright.
Your Honor, I would ask to stop the witness at this point because he's totally non-responsive.
All right, counsel. Again, if you have an objection, just say objection, non-responsive.
Objection,
without anything else.
non-responsive.
All right, let's have the question read back.
Question. Now, the confidentiality agreement you said was in your house, and if Eric and Lyle came upon that on the night of October 31st, they might think that what? That you would already have told her something?
I don't know.
Okay. Now, let me ask you this. Did you also have the confidentiality agreement from the cleaning company in your house that night?
First of all, I didn't ever testify that I had a confidentiality agreement from a cleaning company.
Did I misunderstand?
I think you did.
Do you have a confidentiality agreement with the people who clean your office?
No, and I didn't say I did.
Do you have a confidentiality agreement with your secretary, Sandy Lembeck?
I believe so.
Did you warn Sandy?
No, I didn't.
And in fact, Sandy Lembeck works at your home, or at that time worked in your home with the files, did she not?
No, she didn't work with any patient files at all.
She was
worked
in
with-
your house?
Yeah, she worked with bookkeeping files. She didn't have anything to do with the actual session notes. And in fact, I made that clear to Eric and Lyle because they asked about it.
She worked in your house, what, 2-3 days a week?
I don't recall how many days a week, but she did work in my house several days a week.
Okay, and that's where the patient files were kept?
She was not in contact with the patient files.
Is that where the patient files were kept?
No, she was not in the physical location where my patient's note files were.
Are the patient files in your house?
Yes, somewhere in my
Is
house.
Sandy in your house?
She was in my house in a separate office, yes.
Same house?
Same house.
Was Sandy prohibited from leaving the office while she worked in your house?
She wasn't prohibited from leaving the office. She certainly didn't have any permission to go into my bedroom closet.
Neither did Judalon Smyth, isn't that true?
No, she did not.
And in fact, Judalon Smyth had nothing whatsoever to do with patient files or patient records. Isn't that true?
That's true. Except for tape duplication.
We'll get there. Now, the confidentiality agreement, you said you had a whole file of confidentiality agreements, didn't you?
I don't think I said I had a whole file. I said I think that they were kept somewhere, and I didn't keep them. I'm assuming that we have confidentiality agreements in a file.
Well, you just said you knew there was a confidentiality agreement with Judalon Smyth at your house. That was one of your 4 reasons for telling her.
I recalled that agreement.
So you knew that one agreement was in your house?
I knew we had an agreement. That's correct. I just didn't think that I referenced knowing about files. I don't really look through my files administratively that often.
Did you have a confidentiality agreement with Judalon Smyth at your home on the night of October 31st?
I believe I did.
You think so? You know so what?
I thought so.
Okay. Did you have a file that you maintained in your home office that contained the confidentiality agreements that you've previously told us you routinely had people who worked for you make out?
I believe so and thought so at the time.
So, am I correct in stating there was a file in your house with the confidentiality agreements?
There probably would have been.
And how many people's confidentiality agreements were in that file?
I'd be guessing.
Guess.
I don't know. Could be 25, could be, I don't know, some number like that. I just would be guessing.
And am I correct that you never warned any of those people except Judalon Smyth?
That's correct.
Now, let's talk about the large number of business projects, okay? Now, this was paperwork of some kind?
Excuse me, what was paperwork of some kind?
The business projects.
Well, there was verbal conversation and meetings about the business projects, but yes, what was kept in the house was predominantly paperwork. There also were some tapes that she had sent as examples of things that she did. They were work projects.
You were trying to establish some sort of business projects with Miss Smith,
Ms. Smith was trying to establish some business projects with me.
and you were having meetings with her and having oral discussions about going into some forms of business together?
That's correct. She approached me to go into business with her.
Okay, well, clearly the meetings and the verbal discussions are not at your house on October 31st. Let's focus on the paperwork,
Some notes of the meetings were at my house.
okay? And let's focus on the paperwork. What kind of paperwork are we talking about? What does it look like?
I believe, as you know, Ms. Abramson, I haven't seen that for 4 years. I think it was
Excuse me, Your Honor, could
seized.
the witness be admonished not to refer to what I know or don't know?
Yes, if you could just answer the question as to the description of this, if you can. If you can't, just say that.
Thank you, Your Honor.
Now, could you describe for the juries what paperwork there was at your home concerning business projects proposed by Ms. Smith?
Yes, there were a number of different business projects. I'm simply referencing that I haven't seen any of it for 4 years, but there were a number of business projects that had to do with tape recording, psychotherapy, types of tapes that relate to, for example, relaxation training, things that might be of use to people who had phobias, anxiety disorders, things that could be of use to people in the general population as a way of educating them and being a benefit for the kinds of conditions they had. And she was proposing to do the tape duplication and production for those, and she was suggesting that that I be the person who was actually providing the substance of these psychological educational tapes. So that was one of the projects that we had worked
Can
on.
I stop you for a second? I really don't want you so much to describe the projects as the paperwork that memorialized them at your house, okay? If I broke into your house that night, Dr. Oziel, okay, what would I have found that told me anything about Judalon Smyth?
Well,
That's what I'm asking you. So tell me what the papers look like.
I can't tell you what they look like. There were just maybe 40, 50, 60 pages of different projects that all summarized different business projects she was proposing to me that was the subject of her initial call to institute a business relationship.
And do you recall at one point in the summer of 1990 being asked to bring to court all of the paperwork that was at your house October 31st that referenced these business projects proposed by Ms. Smith?
Yes, I do.
And did you bring all those papers to court?
I brought all the papers that I could locate at that time. That's correct.
And if I understand what you're saying, Ms. Smith was proposing, let's strike that, she owned a little store where she had tape duplicating, is that right? She had machinery to duplicate tapes.
Her whole business and store was, quote unquote, was devoted to nothing but tape duplication and tape production. And
Okay,
there
that
also was
just-
a tape production facility in the premises of her store.
Okay, so that's the business that she was in. She was able to produce commercially tape recordings and to duplicate tape recordings, correct?
That's correct.
And what she was proposing is that, you or others or however could come up with tapes in the area of psychology, and she wanted to be the mass producer of them. That's how she'd make money, duplicating these tapes that you and whoever else wanted to try to get out to the public. That's what the business proposal was, isn't it?
That's correct. I don't know that she had approached anybody else but me. To the best of my understanding,
Okay.
she was trying to do that with me as a business project.
That's sort of like the self-help thing, like self-help books. This was self-help tapes. That's basically what it was.
Well, they weren't necessarily self-help. They were intended to be educational and informative as opposed to doing therapy on tape.
All right, but they weren't supposed to be tapes of your patients, were they?
No, they weren't supposed to be tapes of my patients.
And you didn't have any business proposals in your house that said that you would give her patient notes for her to make them into tapes, or that you would give her patient tapes for her to duplicate? Nothing like that was in writing in your house. Isn't that true?
No, I don't believe anything. Not on October 31st. Nothing like that was in writing in my house.
So if they had broken into your house that night, Eric and Lyle would have found this proposal for commercial tape production, love letters, and maybe a confidentiality agreement. Is that right?
In combination with, yes, that's what they would have found, in addition to the personal letters that also tied in a personal relationship.
I think I mentioned those. How
I'm
large
sorry.
a house was this? How many square feet in that house?
I don't recall, approximately 6,000 square feet.
Pretty big house.
Pretty big house.
And you had an entire office in this house. Is that right?
Yes, there was.
And I take it there was substantial paperwork in the office in that house.
Yes, there was.
And your fear, if I understand you, of Eric and Lyle that night was that they wanted to kill you for what you knew. Is that right?
That's correct.
So you weren't afraid they were going to burglarize your house to steal, did you?
I was afraid they would break into the house to look for information about who might have access to information in my house. Yes, I was.
And they would have found out, you had a lot of other business deals going on besides stuff with Judalon Smyth, didn't you?
I had some.
Overruled.
I had some.
And I take it this house of yours had, in this office, had a Rolodex, didn't it? Lots of names on it.
Yes, it did have a Rolodex.
And I'm sure you had personal address books like we all had in your house.
Somewhere in my house, yes.
And didn't you, in fact, previously testify that you were concerned that if Eric and Lyle broke into your house, they might find Miss Smith's business card or her name on your Rolodex? Did you previously said that?
Yes, there were a number of business cards that existed in my house that related to Miss Smith, and they all had to do with tape duplication. And the best of my memory at the time this took place, I had mentioned duplication and recording to Eric and Lyle that night, and that's the reason that I was very concerned about them linking duplication, note-related things with my practice, the confidentiality agreement, and a personal relationship with Ms. Smith to tie together that this person may very well be somebody who might have information that would be damaging to them, in addition to their ability to follow me, track me, and to discover that there had been a relationship with her. Yes, all of those things. And by the way, all of this took place in 10 minutes.
Excuse me, Your Honor, but could I move to strike the entire answer as violative of the 402 instruction and approach?
All right, objection is sustained. The answer is stricken as non-responsive to the question, and both juries are admonished to disregard it. Did you want to approach?
Yes, please.
Okay. All right, ladies and gentlemen, we'll be in recess until 1:30, and we'll resume at that time. Both juries return to your respective jury rooms. Don't discuss this case with anyone. Don't let anyone discuss it in your presence, and don't form any final opinions about it, and we'll resume at 1:30.
Dr. Oziel, earlier you testified that at your home on October 31st, 1989, you believed there was a confidentiality agreement signed by Judalon Smyth at some point in June 1989. Is that right?
I believe that, yes.
May I approach, Your Honor?
Yep.
One man have a document on a letterhead, Beverly Psychiatric and Psychological Center, may I mark Exhibit 101.
101.
Showing you this Xerox copy. Does that appear to be a copy of that confidentiality agreement?
It appears to be a copy of a confidentiality agreement signed by her, yes.
And if you look at the top of that document, does that document appear to have been transmitted at some point by fax?
It appears to be, yes.
And does it appear to have been transmitted by your fax?
That's correct.
Okay. Now, talking about confidentiality agreements, you testified this morning that you did not testify that the cleaning person responsible for cleaning your office had signed a confidentiality agreement. Am I correct in that?
Objection, this states the testimony.
Sustained.
Right. Do you recall this morning I asked you if the cleaning person had signed a confidentiality agreement, and you said no, and I asked you if you had, in fact, previously testified that they had, and you said no, you had not given that testimony.
Objection, this states the testimony.
Sustained. There was a difference between a cleaning company and a cleaning person. There was different questioning on that subject.
Did you have the cleaning person who cleaned your office sign a confidentiality agreement?
Yes.
And what's that person's name?
Well, we have one now.
I mean then.
I don't even recall who the person was.
I mean then.
Yeah, I don't even recall who that person was then.
It was just one person who cleaned your office?
Yes.
And this was a freelance cleaning person? Didn't work for a company?
No. Yes, that's correct. They didn't work for a company.
And was that confidentiality agreement in this file of confidentiality agreements in your home?
To the best of my belief, it would have been, but I don't recall having ever looked.
Now, you've testified that you remained at your office for between 15 minutes and half an hour on October 31st after Eric and Lyle had left. Is that right?
That's my best estimate.
And then you immediately left and went to Miss Smith's.
Best of my recollection.
Now, did you write anything down concerning the session that you had had with Eric and Lyle before you left your office that night?
Not that I recall.
Did you write anything down concerning that session when you got to Miss Smith's house?
Not that I recall.
Do you recall whether you ever wrote up session notes concerning that session?
I wrote a journal that had to do with my feelings, not about any specific information having to do with Eric and Lyle Menendez.
Now, you say you wrote a journal. Is this something that you had? Did you keep a journal?
I kept it. I don't know where it is. In fact, I looked for it and do not know where it is now. But I kept a journal. It did not relate in any way to Eric and Lyle.
Let's back up.
Okay.
Were you in the habit and practice of maintaining a journal in which you would write down certain things about yourself from time to time?
I was in the habit for some time of keeping a journal that just related to reflections and things that I was thinking about from time to time. That's correct.
That's yes?
That was a clarification of your question.
Was that yes?
Not to your question, to my clarification.
Did you keep a journal that from time to time you would write things in?
Yes.
And did you at some point write things in that journal that related in any way to October 31st and what had occurred between you and Eric and Lyle?
No.
So you never put anything in that journal about your thoughts or impressions or feelings that were in any way connected to what had occurred on October 31st with Eric and Lyle. Is that your testimony?
I might have, but it was not in relationship to them, only in relationship to whatever musings or feelings I was having that didn't refer in any way to Eric or Lyle Menendez.
Musings and feelings you were having about your life in general, or musings and feelings that were stimulated or caused or provoked by what happened between them and you on October 31st?
I would say my life as it was developing, and there was no mention of anything on October 31st or anything about Eric and Lyle Menendez.
And why do you bring up that journal at all in this proceeding, Dr. Oziel? Why did you mention, when I asked you if you ever wrote anything down whatsoever about October 31st, why did you mention the journal? What relevancy does that have?
It probably has none.
So you just mentioned it for no reason?
No, I mentioned it because I was trying to be thorough and comprehensive and mention anything that I was writing at the time. So I wanted to simply disclose to you that I kept a journal, and upon reflection, it probably bears no relevance whatsoever to this.
Did you actually write down some general impressions and recollections of things that occurred during that session in a journal?
I think I've answered that. No.
And your answer is no.
That's correct.
Calling court and counsel's attention to the June 15th, 1990 transcript, page 19. Line 15 for the question. Did you testify on June 15th, 1990 in the Santa Monica Superior Court in an in-camera proceeding before the Honorable James Albrecht in this case?
I did.
I'm going to read you a question and answer from that proceeding. Question at line 15. You didn't make any notes at all? Answer. I did actually write down some general impressions and recollections of things that occurred during the session, but they weren't in the form of standard psychotherapy notes, more in a journal form to log what happened. Did you also testify at that in-camera hearing that you kept that journal in your safe at the office?
I don't recall where it was at that time.
Did you have a safe at your office?
In my office at home.
Did you have a safe in your office?
When you say my office, could you please be more specific?
What do you call your office? The place at home or the place where you meet patients?
They're both offices.
I might have a moment. Do you have, is there a safe at your business, at your previous business location on Bedford Drive?
No, there is not.
There is a safe, however, in your home,
That's correct.
and it's in that office section of your home.
That's incorrect.
Okay, where is it in your home?
Well, it's in, or was in, the same closet that I kept my personal patient files in my bedroom. So the safe and my personal patient files are in the same location.
Do you recall ever keeping that journal in that safe?
I don't recall it, but if that's what I stated, that's probably where it was at the time.
Do you recall being asked on June 28th, 1990, whether you still had the journal?
No, I don't recall.
Would it refresh your recollection if I show you a portion of the transcript of those proceedings?
I'm sure it would.
I propose, Your Honor, to show the witness a page from the June 28th, 1990 transcript, page 128.
I'll show it to him.
Okay. It's
June 28, page 128.
June 28, 128, yes, sir. Starting line 27, Your Honor.
Thank you. Line 27?
Yes, if you would
Yes.
just, if you would just read that to yourself, sir.
Mm-hmm. How far would you like me to read?
Just read the bottom two lines.
Okay.
Okay?
Okay.
Does that refresh your recollection as to whether you still had the journal or believed you had the journal in June of 1990?
Yes, I think it says I believed I did and I hadn't looked at it.
Okay. Now, after that, did you look for the journal?
No, I didn't.
You've never looked for the journal?
No, I haven't.
Now,
Well, I shouldn't say that. I should say that I haven't seen the journal since that time and don't know where the journal is, but it didn't refer to anything having to do with the Menendez case.
Your Honor, we'd like to move to strike that part of the answer. There was no question pending, and it's
Right,
not.
the objection sustained, the answer is stricken.
Okay.
Well, Dr. Oziel, you heard I read the previous part where you said it clearly did have your impressions of things that occurred during the session. You heard me read that to you.
I heard you read that statement. However, if I can explain what I meant by that, I'm sure it would help the court understand that that was not meant to in any way represent that anything written in the journal specifically related to Eric or Lyle Menendez or the specific things that happened, but rather simply some expressions of feeling that I had at the time.
Feelings caused by what happened with them, correct? Your state of mind,
You know,
right?
to be perfectly honest with you, that was 3 or 4 years ago.
And you don't remember?
I don't really remember. I haven't seen it in 4 years.
You haven't seen the journal in 4 years.
Well, I haven't seen the journal approximately in 4 years. That's correct. I don't know where it is. I might add that the journal began long before the Menendez situation arose. It was just sort of a logging of feelings over time.
Can you explain to me, given what you've just said, Dr. Oziel, why you used the following language? I did actually write down some general impressions and recollections of things that occurred during the session. Now, why did you use the term recollections of things that occurred if, as you're now telling us, this had nothing to do with the content of the session?
The answer is that I don't know why I used that specific language 3 or 4 years ago, but that's not my recollection now.
Okay, do you recall that in December of 1991, both myself and Ms. Lansing, on behalf of our clients, sent you authorization and request to furnish and release information and to examine and copy records? Do you remember you received those from us?
I don't remember it, but I'm sure if you represent that happened, that happened.
Well, you recall that we sent you a document and a demand letter asking that you provide us with any and all documentation, and I can show this to you, that in any way referred to anything that happened between yourself and our clients.
As I said, I'm sure if you're telling me that you sent that to me, that you did.
Well, let me just show it to you so that it's clear. In fact, I'll show you both.
Okay.
May I approach, Your Honor?
Yes.
Your Honor, I believe
Excuse me, Your
that
Honor, there is no question pending.
I'm believing that the
Your Honor, I would
Wait a
object-
second, wait.
sorry,
Yeah.
that the testimony or that what she just related that I said is not what I said. As I'm reading it, it doesn't say things. It doesn't say the words that I supposedly said. I'm reading
But you're
the.
referring to what now? What
I'm
transcript?
referring to what the writings in the journal contained.
Okay. All right. If the lawyers want to pursue it, they can.
Your Honor, why don't we take that transcript away from the witness, because I think he's confused that transcript with a different day's testimony.
Go ahead and ask another question.
I'm just
Go ahead.
waiting for people to finish what they're doing. Your Honor, might I mark one of these documents, which is on my letterhead, as 102, and it consists of 4 pages. The first is a cover letter, and the second through 4th page are authorization and request to furnish and release information and to examine and copy records. and that's 102. 103 contains a cover letter on Miss Lansing's letterhead and a similar document, the next 3 pages. And then I would like to mark as 104 a cover letter on Miss Lansing's letterhead and a 1-page authorization to furnish and release. And I'm going to mark, although I don't have it in my hand right now, as 105 a 1-page cover letter and 1-page authorization to release on my letterhead, and as 106 a letter on Dr. Oziel's letterhead.
Did we see 105 on one side?
Yeah, I'll show this. Yeah, you can see this as well. Now, why don't you examine, Dr. Oziel, these 2 documents, 102 and 103.
Okay, I'll examine that.
Would you see if this one is virtually identical?
It appears to be.
No, why don't you look at it more carefully, just to be sure.
Okay, I will. Okay.
Now, if you would be good enough to close that transfer panel. When you received these authorizations and requests to furnish and release information in late 1991, did you at that time make any effort to locate the journal?
No, I did not.
And you have testified, I believe, just a moment ago, that the journal was started long before the events of October 31st, 1981, correct?
To the best of my recollection.
It was something, a resource that you used for your own purposes from time to time and
Just-
maintained.
No. Yes.
And I take it you used it after October 31st also.
I don't know that I did.
Okay, so all of a sudden you, after making some entry, prompted in some way, by October 31st, you stopped making entries in this journal?
Well, I made a very specific decision to stop making entries in the journal.
And did you put the journal in some safe place?
I really don't recall what happened to the journal because I simply made a decision not to continue writing documents of what I was feeling in an ongoing way in a journal. I thought that wasn't prudent given the circumstances.
So you had written something in it that was a product in some way of October 31st, 1989 with the Menendez brothers, right?
No, I didn't say that.
Well, I read to you testimony in which you did say that. Are you now saying that testimony was untrue?
No, I think you've mischaracterized it.
You think I mischaracterized the testimony I read to you?
Or you've misunderstood, or I wasn't clear about what I was saying, one or the other. But that's
Well-
not, I was never intending to say, and it is not my recollection, that I wrote down things in the journal that in any way pertained to the Menendez case. I think I've testified to that.
Okay. Now, is it your testimony now that you do not have any recollection of ever keeping that journal in your safe?
I don't recall where it was kept, but if I said at that time it was in my safe, it probably was, because my recollection then about the journal would probably be better than my recollection now in terms of where it was kept.
And then, being June of 1990, do you recall being asked, where is the journal now, and saying, I believe in my safe?
I believe I did state, I believe it's in my safe.
Pardon me, page and line,
Oh, I'm sorry, this is the 27th? June 27th, 1990, transcript, page 54. And I'm going to read another section onto 55. I propose to read, starting with the answer on line 20 through page 55, ending with line 1. Okay? All right. Read you from your testimony of June 27th, 1990. I should clarify, because the word notes is a vague term. I think I testified the last time that, in fact, I did keep a journal that were not technical psychotherapy notes, but a journal I kept in my safe. Question: where is the journal now? Answer: I believe in my safe. Question: and they related to the interviews you had with Mr. Menendez, either one of them? Answer: it may contain information. I believe it does, as well as other information. Now, do you understand that testimony? Would you like to read it also?
No, I heard what the testimony was.
All right. Now, let me go back for a moment to the testimony that you think I've misunderstood or you've misunderstood of June 15th. Would it help you to actually read this page of prior testimony to see if you were in error or I misunderstood it?
It sounds like I'm recalling something different now than what I said then.
And what do you think, Dr. Oziel? Do you think that a little over 3 years ago, your memory of what happened nearly 4 years ago might have been better than it is now?
One would assume that, but I have no recollection of anything contained in that journal having anything to do with the Menendez case. And I think that there are other things that I stated in those hearings that are consistent with what I'm testifying to right now. I think that you picked one statement at one point, but there are other statements that do say that all that are contained in that journal that were made at the same time as the statement you just picked out are simply my feelings and things that relate to me, with nothing specific about the Menendezes and nothing specific about the situation. So I think that you've picked out one sentence that seems to be contradictory without relating to other sentences that I saw that are consistent with what I'm testifying to today.
I'd move to strike that entire speech, Your Honor, as not responsive.
Objection overruled. The answer will stand.
Well, I'd like to approach that.
No,
This
go on
witness is
with
going to
your-
be his own lawyer.
Counsel, there's no need to approach because we're not going to have you approach. And there's no need for you to make any speeches. If you have
Well,
reason to
my
address the
position is
court, I
witness was
will let you
making a
do
speech.
that. But the answer was the witness's answer, and that answer will stand. And you may ask your next question.
You feel I'm picking on you, Dr. Oziel, mischaracterizing you to these jurors. Is that your position?
No, I think you're doing your job, Ms. Abramson.
I see. Now, we sent you that authorization and release for information, and you did not look for that journal. Is that right?
That's correct. I didn't characterize it as being relevant.
I see. Did you consult with your attorney or attorneys before you made that decision?
Didn't feel there was any requirement to do that whatsoever.
Okay. Now, let's take a look at the other documents. Now, you recall the date on that request and authorization was December 1991, correct? The ones you just looked at?
I believe so.
Now, let me show you 104 and 105, and would you tell us what the dates are on those documents?
November 15th, 1991.
Okay. And would you take the cover letters aside and take a look at the underlying document? And do you recognize that to be a much shorter and briefer authorization and request for information?
Yes, I do.
Okay. Now, let me ask you, Dr. Oziel, when you received the two cover letters of November the 15th, and you received those short form authorizations, was it your belief that you had no records or files in your possession, no patient information whatsoever at that time concerning Eric and Lyle Menendez?
I don't purport to remember what I had in my mind November 15th, 1991. I don't recall.
Well, do you recall if you ever complied with either of these authorizations, either the short forms you got in November or the longer ones you got in December, by furnishing any patient information or patient records?
I believe, based upon my practices, that I would have made an effort to comply and send you records that I have, but I don't remember anything about the specific date.
All right, but do you remember whether you had any records?
I don't believe I had any more records in my possession at that time. I don't recall having any specific records. I think that the actual records the physical records were all seized, I believe, when
Pursuant to the search warrant,
That's correct.
Okay, so that's what I'm getting at. In November of 1991, you got these short form authorizations, and you believe you had no records concerning these two patients because they were all seized by the police, correct?
To the best of my belief.
Right. And therefore, upon receipt of those short forms, you sent me this letter dated December 11th, 1991, which is marked 106. Is that right?
Yes.
And that's your signature, isn't it?
Yes, it is.
And would you read what that letter says?
Correction hearsay, never approach.
Yes. Let me see it.
Let's put aside for a moment, Dr. Oziel, the issue of whatever you may or may not have written in this journal, okay? Did you make any other written notes of any kind that memorialized or referred to the session that you had with Eric and Lyle on October 31st, 1989?
No, I did not.
Is the only form of notes that you ever created for that session a tape-recorded set of notes?
That's correct.
And when you made that tape recording, is it true that you had no written material whatsoever to refer to?
Yes, that is correct.
And to the best of your present recollection, when did you dictate those notes?
Sometime between 1 and 2 weeks after the session of the 31st.
Then I take it was also after the session of November 2nd.
You're correct.
Did you dictate the notes of October 31st on the same day that you dictated the notes of November 2nd?
I don't recall. I may have.
Is it possible that you dictated one session right after another?
It's possible. I don't recall.
Do you remember that both sessions wound up on that one cassette tape?
No, I don't, but that seems plausible.
How many other patients, and I have the books for you if you like, how many other patients did you see between October 31st, 1989, and say 2 weeks from that date?
I don't know. I'd have to see the books or
Let me get them.
estimate.
Let me have both of them. Oh, hold on. Now, I'm showing you your calendar book or appointment book from 1989, which has been marked Exhibit 98. And I'd ask if you'd like a piece of paper to do some calculation, I can give you one. Do you have a pen?
Yes, I do.
Okay. Do you want to take a look then? You see on this page October 31st, correct?
Yes, I do.
And if you would just peruse the book and see between October 31st and 2 weeks from then, if you would simply see how many patients you conducted sessions with.
Would you like me to add both 1 week and 2 weeks, since I'm not sure whether it was 1
Certainly.
week or 2? Okay, thank you.
Yes.
The other.
Approximately 33 at 1 week from the 31st, and approximately 54 by the time 2 weeks had elapsed.
Okay, 54 patient sessions, is that what you're counting?
That's correct.
Now, Dr. Oziel, you had a group of patients who were, in a sense, regular patients. They had a regular standard appointment week after week.
That's correct.
Okay, this is a standing, they reserve time, is that correct?
That's correct.
Now, when you dictated the notes of October 31st and November 2nd, were you alone?
Yes, I was.
And where were you physically?
I was seated on the bed in my bedroom.
So you dictated these at home?
That's correct.
And you had a tape recorder, I take it, at home?
That's correct.
And I take it your wife was not present?
She was not.
And Miss Smith was not present?
She was not.
And what did you do with the tape recording after you've completed dictating these 2 sessions?
To the best of my recollection, I put it back in the safe in our bedroom, and I think I probably kept it to dictate ongoing sessions as they occurred.
Okay, so you put this tape that you had just made in the safe in your bedroom.
Best of my recollection.
Now, would you agree that you could have written up handwritten notes of these 2 sessions had you chosen to do so?
Yes, I could have.
You mean you hadn't hurt your hand or anything like that?
No, my hand was functional.
Okay. You decided, however, to make a tape recording instead.
That's correct.
And I think you've already testified that your general practice was to do written notes, not tape-recorded notes.
That's true in general, for brief notes.
And was there some reason, based on the nature of this material that you were dictating, that led you to choose tape recording?
Absolutely.
Okay. Did you think, I think you've previously said this, that tape recording was somehow safer?
Absolutely, I felt it was safer.
Now, would you describe for me the size or dimensions of the safe in your home?
I would be estimating. I'm
Well,
not sure.
Well, safes can be itsy-bitsy, or they can be walk-in vaults.
No, this is a large enough safe to house files, materials, things of that nature.
So certainly written notes would have sufficed as far as the capacity of your safe to hold them. It was big enough.
That's correct.
And at some point, did you take that tape and have copies made of it?
That's correct.
And do you remember when the copies were made?
No, I don't, but it was definitely sometime after the October 31st and November 2nd sessions.
Well, I would assume it was sometime after you created the original cassette.
Right.
All right, so we have an original cassette. We've just put it in your safe at home.
Right.
Okay? Sometime later, you take it out of that safe and have copies of it made, correct?
That's correct.
And did you then take all those copies and put them back in your safe at home?
I don't recall whether I did that at that point or whether I put them in the safety deposit box. I'm not clear on it.
Let's turn to that for a moment, the safety deposit box. The search warrant that was executed on your property occurred on March 8th, 1990. Is that right?
It sounds right.
Okay, let's just assume that's it for now.
Right.
Do you know how long before March 8th, 1990, you put the tape and the copies of the tape in the safe deposit box?
No, but they had been there for some time. I
Okay.
just don't recall how long.
I need, yeah, but I want the original. Excuse me. Now, I take it based on what you've said, Dr. Oziel, that you made this dictation purely from memory.
That's correct.
And you have a transcript that's been prepared of that tape that you've been utilizing in your testimony.
That's correct.
Do you have it on you?
Yes, I do.
How many pages long is that particular copy of the transcript?
Objection or relevant, Your Honor.
It appears to be 20 pages long. I can't tell if it's double-spaced or what. Approximately 20 pages.
And that 20 pages contains your dictation that relates to both October 31st and November 2nd, correct?
That's correct.
Do you know or recall how long the tape is? How long you spoke into that tape to create the material that's transcribed in those 22 pages?
No, I don't.
Your Honor, I have a two-page document. I'd like to mark, I think, is 107 the next number?
Yes.
And what I think I should do is staple it now so that it's clear that it's a two-page document. The first page appears to be a copy of a safe deposit box signature card, and the second page appears to have a duplicate of that card and also a record of visit safe deposit. Thanks. That may approve.
Yes.
Okay.
Now, Dr. Oziel, have you ever seen this document or the original of this document before?
I'm assuming I have only because my signature's on it, but I don't recall the document.
Does this appear, however, to be the card to the safe deposit box that was the subject matter of that search warrant?
Yes, it appears to be.
Now, directing your attention to the second page, the record of visits, there are a series of dates stamped there, are there not?
Yes, there are.
Now, it appears, does it not, that this box was originally obtained by yourself and Mrs. Oziel on February 21st, 1989.
Appears that way.
Now, if you would scan down the list of dates to see if you can locate the first date after October, I'll strike that, after November 2nd, 1989, where it appears that someone made a visit to the box.
Okay. April.
Well, that's April 89. We're looking for after October.
Oh, I'm
89.
sorry. Okay.
After November 2nd.
We have a December 7th.
So December 7th, 1989 is the first time that there's a visit after November 2nd, is that correct?
That's correct.
And the next time, I think you can only read the month. What's the next month?
March.
March something or another.
March something.
Clearly before March 8th, however, because the last visit is March 8th.
That's correct.
You have a moment, Jerome?
Yes.
It appears from that record, does it not, Dr. Oziel, that the earliest time when you could have put the tape and/or any duplicates of the tape in a safe deposit box was December 7th, 1989?
It appears that way.
Now, Dr. Oziel, was there some particular reason why you waited as long as 2 weeks before you dictated these notes?
Yes.
Well, okay. Tell us what it was.
The main reason is that I was completely distracted and focused on how to manage the therapeutic issues and how to manage the danger factor with respect to this whole situation, and my first priority was not taking notes or dictating notes.
But you were not too distracted to spend 54 patient sessions with patients. You could still function in that capacity, correct?
Yes, I was seeing patients.
Now, did you, in 1991...
Up to 54 patients.
Yes, up to 54.
33 to 54, right.
I remember the numbers.
Yeah.
In 1991, did you make a claim for disability to your disability insurance carrier, which I think was Minnesota Mutual?
Objection irrelevant, and report, please.
Yes.
Pull it out, Mike.
All right, before that area is discussed, the prosecution may review the records, and also the witness wanted to be heard outside the presence, so you go on something else.
All right. We'll leave that for the moment. Dr. Oziel, had you ever, prior to this day, when you dictated this tape of the October 31st and November 2nd sessions, had you ever created a tape recording of dictated patient notes?
Yes, I had.
And on how many prior occasions had you done that?
Numerous occasions.
Numerous.
Dictated patient sessions? Numerous.
Okay. And where had you kept those tapes?
Usually in the same place,
Which was?
which would be in the safe. Most of those were microcassettes
And you kept those tapes in the safe in your house.
until they were transcribed.
So those would be transcribed into some kind of report form?
Transcribed into written notes sometimes when I, in fact, dictated instead of writing.
Now, you told us that generally you write notes, so was there some reason why on some occasions you would dictate?
Sometimes I just didn't feel like writing extensive notes, and I would dictate them and write them at a different time.
And then you'd have someone else, like a secretary, type those up for you?
Or sometimes I would take the dictation and simply write it out. I would just dictate the notes as a way of making sure I captured what had occurred, and then subsequently write them up.
You wanted to make sure you captured it accurately close in time to the session? Is that what you're saying?
Sometime near the time the session occurred, yes.
Okay. And then later you might play that tape back to yourself and handwrite the notes?
That's correct, sometimes.
You never put any of those tape recordings in a safety deposit box, though?
No, I certainly didn't.
Did you have a patient in 1989 who you described to Eric and Lyle as a hitman?
Yes. Oh, no, I didn't have the patient in 1989, no.
Had you had him prior to 1989?
There had been someone who had committed crimes that I had treated.
That wasn't my question. My question was, first of all, did you have a client who was what you called a hitman?
I had a client who had told me that he had committed murder in the past, and I may have described the person as being a hitman.
Well, does the term hitman mean a professional hired killer, a murderer for hire?
I believe that's what it means to most people.
Is that what it means to L. Jerome Oziel?
Yes, that's what hitman means to me.
And did you describe to, or strike that, did you tell our clients that you either were or had in the past had as a patient a professional killer, a hitman?
Yes, I believe I did.
Now, did you ever dictate your therapy notes from the professional killer onto tape?
I believe that I don't recall whether I dictated them or wrote them, to be honest with you.
Fine. So your answer is you don't recall.
That's true. That's the answer.
And do you recall ever telling Eric and Lyle how many people this professional killer patient of yours had killed?
No, I don't.
Do you recall having such a conversation with them in which you did tell them how many people this other patient had killed?
No, I do not.
Do you recall whether the hitman discussion, if I might call it that, was part of your effort to assure Eric and Lyle that what they told you about the killing of their parents was confidential?
No, I don't believe that it was any assurance that what they told me was confidential.
Well, isn't it true, Dr. Oziel, that what you were doing was saying, look, you don't have to, in effect, you don't have to worry, I'm not going to tell anybody. After all, I've had another patient, he was a professional killer, a hitman, and I never told anybody all the dreadful things he told me.
No.
Wasn't that the context of the conversation?
No, it wasn't. No, it wasn't the conversation.
Was there some other reason why you would be telling one patient that you had another patient who committed murder?
Yes, there was.
Now, let me just ask you this, Dr. Oziel. Did you tell that hitman patient of yours this limits of confidentiality explanation that you've given us in court today?
Objection, irrelevant.
Sustained.
Dr. Oziel, do you know what the term dual relationships means in the sense of ethical psychology practice?
Yes, I do.
And how would you define, or how, strike that, what do you understand to be a dual relationship?
A dual relationship is a relationship where someone is simultaneously acting as a therapist, and they are doing so with someone who occupies some other kind of role in life, such as an employee or a relative, where there's some potential for a conflict of interest between the therapist or the therapy and the patient.
And are dual relationships considered unethical?
They're considered a form of relationship to be avoided, is the way I believe it's stated in the ethical manual of the American Psychological Association.
Well, isn't it true that you were placed on probation based on a dual relationship?
That's correct.
And isn't it further true that there is currently pending against you an accusation from that same psychology board that had you on probation also claiming dual relationships.
I haven't seen the accusation, although I'd be more than happy to comment on it and explain it.
Well, no, I'm not going to ask you to comment and explain. I just want to know if you know that it alleges dual relationships. Do you not know that?
I have no idea what it alleges because I know the foundation of it is. Okay. No, I don't know. No, I haven't actually seen it.
Would you like to see it?
That's fine.
Do you have any concern? Well, let me strike that. Are you practicing as a clinical psychologist now?
Yes, I am.
Are you reliant upon your practice as your main source of income?
It's hard to say. I have different sources of income, but yes, I'm somewhat reliant on it as a source of income.
Isn't it true that your income from your therapy practice has ranged as high as $300,000 to $500,000 a year? Isn't it true you cannot practice psychotherapy if you don't have a license?
That would be correct.
And isn't it true that a potential outcome from this accusation currently pending before the Board of Psychology, Department of Consumer Affairs, State of California, is the loss of your license?
That's a potential outcome.
May I mark this document? I believe 108 is next.
Yes.
And may I approach the witness? I think it's going to take them a few minutes to... The question is I'm not going to go into any of the specifics of that allegation, Dr. Oziel, okay? I want you to understand that.
I'd be happy to explain it if you wanted to go into them.
I don't think that the judge would
Okay.
allow you to do that. But the
Okay.
point is, okay, do you know what the legal term gravamen means?
I have no idea.
All right. What I'm asking you is, isn't it true that the general allegation, the basis of the accusations in that complaint, is that you maintained dual relationships? That's what the claim is. I'm not asking if it's true or not. Dual relationships with two people.
I think that among other allegations that I'm seeing here, that's one allegation.
Okay. Now, is there another type of behavior that a therapist can engage in that also is called a dual relationship? A conflict of interest type relationship?
I'm not really sure what you're referring to.
Okay. Are there situations where a therapist can be seeing 2 or 3 or 4 patients, let's say from the same family or group, whose interests are antithetical to each other, where the goals of therapy are antithetical to each other, where an exchange of information between those people would be harmful to one or more, and therefore seeing all those different people constitutes one or more dual relationships?
I've never heard that term used that way, and that isn't the way that it's generally used in the ethical guidelines of psychological associations.
Is there then another term that you are more familiar with to describe that situation where a therapist is basically giving therapy to people who probably should have separate therapists?
I'm not aware of a term, certainly, that's a situation that could occur.
Now, Your Honor, at this point, I need to have some of the pending stuff resolved, or I can't go anywhere,
All
basically.
right. You mean those matters that require the district attorney to review documents?
right.
And all right, so you're about through with your examination, is what you're saying?
No, I have a lot more to do, but I have to review something before I can do it.
Well, why don't you, I mean, you have to review your notes, or what is?
I have to review the transcripts from 2 days ago because we've split this up so much between one jury and two juries. I want to make sure I don't weave off into
Right.
the wrong jury.
So what you're saying is you want to recess so that you can review some things, is that right?
Right.
Okay. All right, then we'll resume tomorrow morning, ladies and gentlemen, and just a few remarks before I excuse you for the afternoon. Again, just to remind you not to discuss this case among yourselves or with anyone else, and not to expose yourselves to any of the coverage of this case in any form or any discussions of the case. Also, just to remind you not to have contact with the other jury. Each jury should keep separate, don't speak with each other, and don't have any contact with each other than, as you walk out or walk into the courthouse, but don't talk between one jury and the other jury. Just keep to your own separate groups. And we'll see you all back here tomorrow at 9 o'clock. Have a good evening. We'll see you back here at 9.